let me get started. So my name is Kirsten Henckel. I'm an assistant professor of private international law at the University of Groningen in the Netherlands. And of course, first I would like to say that I'm happy to be here, and I would like my fellow panelists, to thank my fellow panelists for being here, as well as, of course, all of the participants in this particular session. So when it comes to the issues that I'm going to discuss in this panel, I will provide a short presentation on the law applicable to crypto assets, and I will do so from a Dutch perspective. And in this context, I will make use of the umbrella term crypto assets for financial products issued and registered directly on a DLT network. And this encompasses, among others, cryptocurrencies such as Bitcoin. So before actually starting my presentation, I would like to give a brief overview of what I'm going to talk about. And I will highlight some of the main issues discussed in this presentation. That's what I'm going to do first. And then briefly, I will discuss some of the main features of DLT and how these might impact the application of traditional rules of private international law. And after that, I will address the transfer of assets as well as the proprietary aspects of crypto assets. And I will end this presentation with some concluding remarks. And although this presentation is about assets registered on a DLT, such a network may be perceived as a technical infrastructure that in itself rarely requires a conflict of laws connection. And much more relevant is the question of the law that governs the transfer of assets and their property. And as such, these issues are at the very heart of this presentation. So one very interesting question is, how do we determine the applicable law to these issues? Or how should the applicable law be determined? And in this context, the issue of classification and finding the relevant connecting factor plays an important role. And that also goes for the question of whether the existing mechanisms of private international law are equipped to handle this question of applicable law. But before tackling these issues, I would very briefly like to have a look at some of the key features of DLT. And given the nature of this particular panel and the CODIFI conference in general, many of you will undoubtedly be familiar with these features. So therefore, I think a very brief overview will probably suffice. So I'm doing this to highlight the impacts that some of these features might have, not only on the existing rules of private international law, but also on the way that we think about determining the applicable law. And you can see that this slide provides an overview of some of the key features of deep ledger technology. And the most prominent in light of private international law are, of course, the decentralized nature of the network and the pseudo-anonymity that exists within the system. And I would now like to just very quickly move on to my next slide, which is, of course, one of the main features of private international law is that we generally seek connection to a factual geographic location in order to determine the applicable law. And this means that real-world connections make it easier to find a legal system that is most closely connected to the issue at hand. But this also means that some of the features of the DLT network bring new challenges to finding the applicable law. So, for instance, the distributed and virtual nature of the DLT network makes it difficult to find the location of the network itself, and also of the ledger that it stores and of the crypto assets that are registered therein. And after all, such a ledger is not stored at any one location, but it is distributed among nodes that may be located all over the world. And another difficulty is the location of asset holders. The pseudo-anonymity of the system means that the identity of the parties, as well as their location, is frequently unknown. But before we label any of these issues as problematic, it is important to have a look at the issues themselves and at the conflict of laws connections that arise in this context. So when it comes to crypto assets, I would first like to draw your attention to two main categories, being contracts and torts. And of course, the majority of crypto assets are transferred in a contractual context. And one might decide to, for instance, buy a crypto asset either directly from a friend or to make use of a crypto exchange in order to engage in trading. And of course, subsequently, such a crypto asset may then be stolen, for example, by hacking, which makes us arrive at the category of tort. And when it comes to issues of contracts, the existing instrument of European Union private international law tends to work well. So the special characteristics of crypto assets and the DLT network have little influence on determining the applicable law in contractual matters. And that is because the existing conflict of laws rule in the Rome I regulation tends to see connection to off-chain locations. And of course, the general rule seeks connection to a choice of law made by the parties within the contracts. And should no such rule apply, then the habitual residence of the person affecting the characteristic performance prevails. And therefore, the Rome I regulation works really well in the context of crypto assets. But that is a little bit different when it comes to the Rome II regulation and the issue of tort. There, a little clarification might be needed. So indeed, the issue of tort is regulated by the Rome II regulation. So there one can perhaps think of the theft of a private key. And the general rule seeks connection to the place where the damage occurs. And in cases of crypto asset theft, that place may not be as easy to determine as one might like. So for instance, does the damage occur within the network itself or at the location of the private key? And these places may be difficult to locate. And one might think that here some clarification from the Court of Justice would help. And in my opinion, even though this place is generally not advocated in cases of pure economic loss, the law of the habitual residence of the injured party should prevail. And that's because the regulation seeks connection to the place where the substantive damage is felt. And this is also, of course, a place that is foreseeable for a potential tortfeasor. And in addition, when it comes to a DLT network, there may not be another factual location that is suited for determining the applicable law. And of course, when it comes to tort, there are also some practical issues, such as evidence locating the tortfeasor and the fact that the immutability of the system does not allow you to reclaim your original assets. So therefore, you only have a financial claim. But what about some other issues? Which law, for instance, determines whether someone has rights over crypto assets, whether they have the right to dispose of it and transfer it? What are the conditions for such a transfer? What are the third-party effects? Which law determines whether assets can serve as collateral or as the object of seizure and garnishment? These issues are generally proprietary and associated with ownership. Yet, when it comes to several continental countries, it is difficult to speak of ownership of crypto assets. So, for instance, within the Netherlands, crypto assets within substantive law are not considered subject to ownership, and that is simply because they are not tangible. And by contrast, for instance, the UK or the US, they use a less stringent definition of property that may allow crypto assets to be considered as such. And if we have a look at private international law, when it comes to these issues, we can see that except for a few minor subject matters, there exists no unified or harmonized rules of private international law when it comes to issues of property. And this means that such rules are mostly of a national nature. And when it comes to applying such rules, classification is of course based on the lex fori. And this law will then determine whether it truly concerns, for instance, an issue of property under the conflict of laws. And if so, which category of property and which connecting factor do we apply? And in general, on a global scale, issues of property tend to be governed by the lex requisite, the law of the location of that property. Yet, when it comes to crypto assets, determining that location poses a challenge. After all, crypto assets are not located in any one location. Instead, they tend to be registered and stored on a decentralized ledger that is distributed among nodes that may be located anywhere in the world. And in the absence of any unified framework on this issue, and with the difficulty of that the application of the lex requisite provides, how do we determine the applicable law to the proprietary aspects associated with crypto assets? And this, specifically in this area, this is where I see a clear role for the HCCH. So perhaps it's possible to establish a framework that answers the question, how do we determine the applicable law to the proprietary aspects of crypto assets? And of course, this is a question that is not easily answered. And numerous solutions have already been proposed by academics and some international institutes. And I will very briefly discuss some of these, but primarily I will share some insights from a Dutch perspective. And what we will see is that the Dutch Civil Code holds several conflict of laws rules designating the applicable law to the proprietary aspects of different categories of assets. And many of these categories may be associated with financial products. But of course, in order to answer the question, which category applies, we must apply the doctrine of classification. And looking, for instance, at the first category, the category that relates to tangibles, especially there, we can ask ourselves the questions, could that ever apply? Because of course, crypto assets are not tangible. And in that context, can we even speak of proprietary aspects? And that question, of course, does exist, but one must remember that crypto assets also represent a certain value, that they hold certain rights, that they may be used as collateral and may be subject to, for example, seizure and garnishment. And in fact, in the Netherlands, they have been subject to seizure and garnishment, and they have been used as collateral. So therefore, they bear a great resemblance to assets that can be the object of ownership. And therefore, it might make sense to have a look at these conflicts of laws categories that deal with the proprietary aspects of these different assets. So, of course, as I've stated before, this general rule that relates to tangibles, it does not apply to crypto assets, as these are simply not tangible. And moreover, as I've just highlighted a moment ago, the application of the Lex Recite is difficult to reconcile with the distributed nature of DLT. But a different category exists for claims. And then, of course, the question is, does a crypto asset in itself constitute a claim? And this question is not easily answered, and it's of course also largely dependent on the special characteristics of the asset itself and the system in which it is created. For instance, where it concerns assets that are issued on a decentralized DLT, there's no central issue against which a claim can be invoked. And of course, when it comes to participating in the trade of crypto assets and in the DLT network itself, asset holders have an expectation that they will be associated with certain assets due to the fact that they hold a private key. And they have this expectation that then they will then be able to engage in transactions in relation to those assets. However, asset holders do generally not have a right to performance by another participant or a group of participants in the network. And therefore, at least in my opinion, it's unlikely that crypto assets will be classified as claims under the Dutch conflict of laws. And that, of course, does not mean that they cannot be the object of a claim. Such claims, for example, a right to payment in Bitcoin, may then be assigned to others. And the assignment of claims is generally subject to Article 14 of the Rome I regulation. However, this provision does not regulate third-party effects. And in Dutch private international law, this really does not give rise to that many problems, as this issue is governed by the Dutch Civil Code, which seeks connection to Article 14 of the Rome I regulation, because there too, the law governing the contract and these third-party effects between the assigner and the assignee applies. And these rules on the assignment of claims appear to work well when it comes to crypto assets. However, they do not determine the applicable law concerning the proprietary aspects of these assets themselves. So therefore, let's just have another look at a different category. and that is the category of shares. And crypto assets bear some similarity to shares in the sense that they are frequently used as an investment. However, in most cases, there is no issuing company that assumes rights and obligations with respect to crypto asset holders. The cryptographic collaboration between DLT participants does not constitute a company either. And in the absence of any corporation, it is not possible to apply the law that governs the corporation itself, the lex societatis, which is the general rule when it comes to registered shares. More so, the existing pseudo-anonymity means that crypto assets are not registered by name, which further hinders the application of this particular rule. Instead, of course, crypto assets are associated with the public and private key. And therefore, one might ask whether such a key constitutes a bearer that is similar to that associated with bearer shares. And there, the location of the bearer prevails. But the location of a private key is very difficult to establish, and that is because such a private key, it may be located in a digital wallet, it may be stored with a wallet provider, it may be located on a hardware wallet or simply on a piece of paper, and then this may be stored at one location, or there may be copies at several locations, which makes this particular connecting factor ill-suited for crypto assets. So then Dutch private international law offers one final category, and that is the category that exists for book entry securities. And similar to book entry securities, crypto assets are electronically recorded. But what is different, however, is that with crypto assets, there is generally no intermediary that is in charge of keeping the record. And moreover, when it comes to crypto assets and their registration in the DLT network, there is no account. And this makes the so-called PRIMA rule that was developed during the negotiations of the Hague Securities Convention and that exists in Dutch private international law ill-suited to deal with crypto assets. And a solution has been proposed, has been to apply the PROPA rule, which is the place of the relevant operating authority. And this rule might work for some closed or permission networks that make use of a central operating authority or central administrator, and that may, for instance, regulate access to the network. However, it does not solve the issues that exist with regard to decentralized distributed networks. So what we see is that here, Dutch private international law does not offer a solution. A clear rule or framework that clarifies the applicable law with regard to these issues is therefore welcomed. And such a rule should preferably be easy and simple in application and should be able to withstand technological developments. And as I've said before, this is where I see a role for the HCCH. Rather than establishing new, possibly contrasting conflict of laws rules on a national scale, it would be beneficial to have an overarching rule or framework that applies on a more universal scale. And possible solutions would be to seek connection to the contract, where the conflict of laws rule are not hampered by the special characteristics of DLT systems, or to reluctantly apply the lex fori. Application of the law chosen to govern the asset or the system would also offer a solution. However, given the nature of DLT systems, which generally aim to operate outside any one legal system, this is not a catch-all solution, thus requiring an inevitable cascade. What is clear is that the unique characteristics of DLT networks and the assets stored thereon provide new challenges and opportunities to private international law. And that is especially the case where it concerns the question of how to determine the applicable law to the proprietary aspects of crypto assets. And this presentation has shown that this question is not sufficiently solved within today's private international law frameworks. And as such, this is where the opportunity for the development of new laws that are in line with technological developments lies. So I would like to thank you all for your attention, and I would now like to yield the floor to the next panelist that would like to give his presentation.
It seems that Sarah has not returned yet. Kelvin asked to be the last, so shall I go next? No, nobody else wants, then I'll do. So I'm sharing as well my presentation. Just ask you for 1 second. Okay, you should be able to see this now. And I'll start it. Okay, so after Kirsten, I'm taking another look at this from a more well, general or global perspective, and I'm taking the question that was asked: how is the applicable law best determined, asset, system, or transaction? And I start with this binary choice because this makes things simpler between asset and transaction. And there I think it's really elusive to think we could determine the applicable law either by asset or transaction. I think we need both, because we need to know which law applies to an individual asset, but we also need to know which law applies to the transaction over this asset. And these may be different laws. As Kirsten already highlighted, these are two different fields of law in many legal systems: the law of property and the law of obligations. Now, I'm fully aware that not all of the legal systems of the world characterize crypto assets as property, but what all laws should recognize is that there are two different questions. The one question is, who is currently owning an asset, or who has title, to give it another name, right? And it's the old question of the mine and the thine: what belongs to you, what belongs to me? A very different question is which law applies to a particular transaction. And here we have a more dynamic view: who has a right to become the owner or to get title. It's the question of the I owe you or I don't owe you. And these asset and transaction, they also raise very different questions. So the law that is applicable to the transaction, for instance, asks questions like, were the goods and services of the promised quantity and quality, was a proper consideration, who bears the risk in case of force majeure, for instance. And it has the effect, as we all know, only inter partes, the privity of contracts. Whereas the asset law determines question like, was there a valid transfer? Does the transfer have good title? Was the transferee in good faith? And generally the effect is erga omnes. It means against the whole world. And to illustrate this even more strikingly, let me give you an example where Alice sells 1 Bitcoin to Bob for $20,000, and she actually transfers the Bitcoin to Bob's public address, but Bob sends the consideration to the bank account of a third party, to Chuck. So here we have actually two questions. First question is, can Alice claim the $20,000 from Chuck? And that is a question of transaction law. And actually Alice can, because she merely has a claim, and that claim is with the counterparty to the transaction with Bob, but not against a third party. But when the question is, can Bob defend himself against the creditor of Alice, who wants to seize the 1 Bitcoin, then he actually can, although this is a third party, because he is the owner. So this, I think, illustrates that transaction law only works inter partes, only between the parties to the transaction. Asset law is a question that relates to the whole world. And that's why we also, in private international law, use different conflict rules for these two questions. For transactions, we look at usually the chosen law, or in the absence, we look at things like the habitual residence of the party providing the characteristic performance, in many countries at least. Whereas for assets, we look for things like the location of a thing or the registration in a certain register. And these differences, of course, relate from the fact that party autonomy normally operates only between two parties of the contract, whereas when you have an asset that is valid against the whole world, then you need a criterion that is more visible to the whole world, like the location. Now, the question that was asked here in the title is, well, could we perhaps use the system? And I introduced this as a third connecting factor that might possibly replace the first two. So I rephrased the question asking, may we perhaps determine all the law applicable to all of the assets and all of the transactions of a network to the law of the system, to the law governing that network? That is, of course, a very fascinating question. And I think in order to tackle it, we need to break it down. First, we need to answer the question, can there be such a single law that is governing the system? And probably such a single law must be chosen somewhere. So can there be a choice of this system law for all of the assets and all of the transactions concerning the system? The second very different question is, how likely is it that we will find in practice such a choice? And then the third question is, what will we do if we don't have such a choice? So as to the first question, is it possible to choose the law that will apply to all transactions and all assets that are related to a certain network or system? Well, technically, this is still discussed, but it may be that it would be possible technically to embed such a choice in the code of the system, perhaps in the source code, so that it is readable to human beings. And if that is not done, or is not possible technologically, it may be such a choice may also be included possibly in standard terms that may be popping up, for instance, when the software that is used and required to become a node of a certain network is downloaded, then these standard terms may pop up and possibly they may contain such a choice of law. So technically, that should be possible. However, there are problems. And the first legal problem is that not all interested parties, as I would call them, are connected to the network. For instance, there are persons who may have acquired crypto assets outside of the network. That is indeed possible because if you sell, for instance, I could sell Bitcoin without actually transferring them to a public address on the network. I could simply hand over the private key that I may have stored on a cold storage, on a USB key, for instance, to somebody against consideration. Or I may inherit crypto assets totally without being ever connected to the network, without ever having been a node. But there are also third parties outside the network that may have interests in the assets there. Think of the creditors of somebody who holds assets on this network. So these parties will not necessarily have agreed to a choice of law because they have never connected to the network. Second problem, and that may even be more relevant, is that virtually none, I would say, but that's maybe a little bit exaggerated, but the vast majority of networks do not foresee any choice of law. And that is not simply because of forgetfulness, but that is by design, because the networks were designed in an anti-state attitude, really anti-legal even attitude from a libertarian, anarchical perspective. And it would run completely contrary to the intentions of, for instance, the creator of Bitcoin to provide a choice of law when the idea was to get around the law. So that may be an unreasonable attitude, but it is unlikely, I would say, to change in the near future. So we must think about solutions. What happens if no law of the network has been chosen? And there we have the problem that Kirsten already mentioned. Of course, these systems are global in nature and they have connections to states, but they have connections to all states, or the same type of connection almost to all of them. There is an exception, though, for permission networks, so-called permission networks that have an operating authority that needs to grant permission to somebody to become a node, for instance. They are connected to a state, possibly to the state where the operating authority is sitting in, and we could use this location as a place of the relevant operating authority approach, to term it like that. That would be possible. But for the other systems, all of these permissionless networks like Bitcoin or Ethereum, we must determine the applicable law differently and not by the system. So we must start with the law that applies to the transaction, and then find the law that governs a certain asset. When it comes to the transaction rules, we can mostly use what I would call exogenous factors. That means connecting factors that are not in any way linked to the blockchain. For instance, we may use a choice of a contract law. So if the contract whereby I sell my Bitcoin has been submitted to a particular law through a clause in the contract, now not in the code, but in the contract, then we may, of course, follow this to determine the applicable law to this contract. And if we don't have any choice of law, then we may use the classic connecting factors like the law that applies of the habitual residence of the seller, for instance. We have some special issues, but those are well known as well. We need also to find the law that applies to the validity of the choice. Perhaps we connect the capacity of the parties to a different law. And we may have public policy rules. So that is the transaction law. No major problems here. The real problems lie, as Kirsten also said, in the area what could be termed asset law, and she has called it at some point also proprietary issues. So the mine and thine. How do we solve this issue when we are not in a system where a law has been chosen? Well, this is, of course, difficult because there we don't have any location, so we must find alternative criteria. And the one idea would be to use a waterfall of connecting factors. Very important in this world of the blockchain, which strives to be decentralized, are ironically custodians. Centralized institutions. Most of the digital assets are held not on a cold storage or somewhere else on a piece of paper, but with a custodian, like a crypto exchange or a wallet provider. So very centralized in a way. Why not use, in the absence of any choice of law, why not use the law that is applicable to the relation between custodian and customer as the law governing the asset as long as the asset is in custody. Now this applies, of course, only to those assets that are held with a custodian, but as I said, this is the majority of assets. The law that is applicable to this custody agreement can be chosen, or it can be determined by objective factors like, for instance, the seat of the custodian. Then, as a subsidiary criterion, when we don't have a custody relation, there are many digital assets that are issued by a specific issuer. This concerns all of the tokens that are issued in an ICO, in an initial coin offering. So these have most of the time an issuer, or they always have an issuer, and most of the time the issuer is identifiable. The issuer may itself provide a choice of law in the issuance submitting the token to a specific law, we may follow that choice. And in the absence of such a choice, we might use connecting factors such as the seat of the issuer if it's known. In the absence of that, we may still, even in the permissionless world, we may find a connecting factor to the network. Remember, we don't need something, a law that is overarching or something. We need a more significant connecting factor to one country than to any other. And there are certain permissionless networks that have some connections to specific foundations or other institutions in a specific country. And finally, if we cannot identify that, then as a very, very last criterion, we might think about using the law of the person that is currently in control of the asset. Now, that is, of course, a very flimsy criterion. It's a very weak connection. It may change all the time and so on. But if we don't have any other connecting factor, then we may refer to the person that is in control and specifically to the habitual residence or domicile of this person that is in control actually of the asset right now, and use the law that of the habitual residence of that person to determine who is the actual owner of this asset or who has title to this. We may have to find some exceptions, of course, when control has been obtained illegally, for instance, through fraud or through hacking, but that may be for the parties to prove. And then, of course, you might say, but how do we know the habitual residence or domicile of the person who is in control? Well, don't forget that we will most of the time be in a litigation situation where we have a known claimant and a known defendant, and then we also can identify the habitual residence or domicile of these persons. So to conclude, it would indeed be a good idea to follow one single law, the law of the system, to apply to all transactions and all assets that happen on that system or related to that system. However, this can work only where there is a choice of law or where there are particular systems that are closely connected to one country, like the permission networks that I mentioned. For all other types of systems and cases, we must determine the applicable law individually. First, the law that applies to the transaction, no big problems here. And second, the law that applies to the assets, big problems here, and potentially lots of work to do for the Hague Conference. Thank you very much.
Sarah, are you going next?
Yes, sorry, I wasn't sure whether there was going to be anything in between Matthias and me, so sorry for the pause and sorry for not being here earlier. There was something of a diary mix-up, but actually I think it's worked out quite well because I then got the benefit of hearing what Matthias had to say before I speak, and I think that's given a slightly different direction to what I'm going to say in a very positive way. So I'm Sarah Greene. I'm the Law Commissioner for Commercial and Common Law at the Law Commission of England and Wales. And thank you for inviting me to speak today and more importantly to listen because the Law Commission is currently working in very early stages of a project to look at excuse me, choice of law and jurisdiction in relation to digital assets defined fairly broadly, smart contracts, electronic trade documents, basically the emerging technological issues that we're concerned with on the project. So we've been working on all of those things at the Law Commission in terms of their private law implications. So if at all, so whether private domestic law, these are our other projects, right? So whether private domestic law has to be reformed to accommodate all those things I've just mentioned, and if so, how? Now, in the course of conducting those projects, so smart contracts, electronic trade documents, and digital assets, as I said, broadly defined, I'm going to come back to that, but it certainly encompasses cryptocurrencies and NFTs. The question that kept coming up when we were talking to stakeholders was again and again, what about private international law issues in relation to those things? So that won't surprise anybody here, and in fact it didn't surprise us. But actually for those separate projects, the issue of private international law was out of scope. So we couldn't actually deal with them there. Now, frustrating though that was, as we dealt with those issues on a domestic basis, I think, again, it had quite a happy outcome in that we now have this project that is dedicated to this question. And again, I don't think there'll be anybody here who would disagree with the suggestion that it needs its own dedicated project. It's a very difficult and thorny set of issues. So I am very pleased that we get the chance to look at it in isolation from domestic law, certainly not in isolation from what is going on elsewhere in the world. Obviously, that would be highly, highly counterproductive, which is why we very much welcome events such as these. So before I just talk about the Law Commission perspective and project, which is, I think, what I'm going to focus on today, seeing as the issues that we are envisaging dealing with are, again, unsurprisingly, those that have already been dealt with in this session and in this conference as a whole. I just want to say a couple of words about the Law Commission and how it works, just because I think that gives a helpful context to what else I'm going to say. So for those of you who don't know, the Law Commission is an independent body, so that's a really important point to make. So we are an independent body, we're what's called an arm's length body from government, from the UK government, but we are commissioned by the UK government to look at certain areas of law, and as I've already made clear, that's what we've been asked to do in relation to these emerging technologies and their implications for private international law. But what is really important is that our work and our conclusions are reached on an independent basis. So there is no party political flavour at all to what we're doing, and it's a very intellectual and highly consultative exercise. And it's really the consultation part of it that I want to focus on today, because that links with the point I've just made about there's no point in the Law Commission of England and Wales formulating rules or suggesting proposed rules for how to deal with all the issues that we're talking about today, if that is done with a set of blinkers on and with no consideration of international perspectives and other suggested solutions. So what we do at the Law Commission is we go through stages of a project, we issue a consultation paper, which we then invite consultee responses on. But even in getting to the stage where we put that consultation paper together, we consult very widely. And essentially, the reason that I'm making this point here today is that we are interested in views from anybody who has an interest, who has a view. And that, as I said, goes towards the provisional proposals we make at consultation phase. We then issue that consultation paper and garner even more responses and ultimately make proposals to government for how to deal with the issues that we have been concerned with. Sometimes that results in our also producing legislation or draft legislation for the government. So we have in-house parliamentary counsel that can do that. Other times that will take the form of a report on its own, and that report will contain proposals. So that's what we're in the business of doing. So I wanted to just explain that context of what the Law Commission is and what it does here today. really to underline the point that when we get to the stage, particularly of issuing our consultation paper, we would be very, very interested in anybody's views. But equally, if anybody wanted to speak to us before then, we are definitely in listening mode. So we're in, as I said, the very early stages of this particular project. And what that really means is that one of the most difficult issues, if not the most difficult issue, is that we are trying at the moment, my team and I, to pin down exactly what the scope of this project should be, because of course potentially it is hugely broad. You know, what happens in terms of private international law in relation to digital assets. We have a finite amount of time on this project and a finite amount of resources. So what we're trying to do is to identify and to isolate the most important and the most effective ways in which we can suggest proposals that will facilitate international transactions in relation to crypto assets, digital assets, and smart contracting. So we need to decide, and I know these questions have already been dealt with by other speakers on this panel and before, but we of course need to decide, if we're going to make those proposals, how are we going to limit them? Are we going to look at, say, choice of law in relation to broadly transactions that involve crypto assets, or are we going to, say, focus on those that are characterized as proprietary? So are we going to focus on alternatives to Lexitus, for example? Now that, of course, I think provides the most obvious, I guess, basis for reconsideration, given that CITES is not necessarily an authentic determination to make in relation to some of these digitized assets. But remembering, of course, that there are very good reasons why the CITES is chosen as a means of determining these answers in relation to property. So should we just focus on that particularly difficult proprietary question, or should it be that we take a bigger bite of the cherry, as it were, and try and establish choice of law rules for digital assets in general? Now, that would be, I think, a very big project, but if it's what needs to happen and what is more likely to facilitate, I guess, a sort of smooth transition to the new digital private international law world, then so be it, and maybe that's what we need to do. So these are the things that we're seeking views on at the moment. Now, one point that I wanted to pick up on in relation to endogenous and exogenous assets, so on and off-chain assets, which at the moment I think at the Law Commission we're probably disposed to take a slightly different perspective to some others that I've heard. But again, you know, I can't emphasize enough that we're still in listening mode. But of course we need to put forward concrete proposals in the first place that people can object to or agree with, of course. Both of those are equally welcomed responses. And one of the things that I think is slightly unique to the Law Commission's project at the moment is that we are basing our conflict of laws project on provisional conclusions that we've made in our broader digital assets project. Now, our broader digital assets project, which is at consultation stage, so we published the consultation paper for that a few weeks ago. And one of the things that we do in the digital assets project, and that's, as I said at the start, that's relating to English and Welsh law's treatment, so domestic law treatment of digital assets. So questions like, can you have a property right? If so, what is the nature of that? What happens on transfer? What happens when things go wrong? It's all those sorts of issues that we're looking at in relation to digital assets. But one of the things that we do in that paper is we suggest for English common law, a third category of property. So for a system that has for a very long time worked on a dichotomy between things in action and things in possession, we have suggested that actually now it's time for a tertium quid, a third category of data objects, which encapsulates a lot of the digital assets that we are really concerned with today, such as cryptocurrencies and NFTs, tokens on a blockchain. Now, the reason that I'm being very generic is a very deliberate one, because what we do in that project and in our private international law project is we are very, very keen to be technology neutral, because any reforms that we make, we want to make them as future-proof as possible. We do not want to make any reforms based on a particular technology of the time. I mean, even DLT, of course, that is a solution to lots of what would otherwise be legal problems at the moment, but it may not be the only solution. It probably won't be the only solution in a decade's time. So what we have done in the Digital Assets Project, and it's the basis on which we are taking our private international law project forward, is that assets that exhibit certain characteristics can be seen as proprietary according to those proposals and would fit within this third category of property, of data objects. So things which are not quite things in possession, but are certainly not things in action, and so need a very specific legal treatment. In essence, they can be the object of property rights. Now, of course, that's a very important thing that needs to be established before we can start to look at characterization for private international law reasons. And so our project at the moment is proceeding on the basis of that provisional proposal. So these digital assets can, as a matter of English law, be regarded as proprietary. Now, of course, that's not the end of the inquiry by any means when we're thinking about private international law issues, but it is certainly something that we needed to determine for ourselves. Again, I'd be very interested in views on that as a basis for the private international law determination and in its own right. But the other thing is to come back to the endogenous and exogenous asset question. Another conclusion of our digital assets work in general has been that that distinction isn't always bright line or clear cut, and for the purposes of a proprietary analysis, an on-chain, well, actually I'll leave purely aside for the moment, but an on-chain token that represents something valuable off-chain can in and of itself also be a discrete data object for the purpose of a proprietary analysis. And that doesn't preclude a similar analysis being applied to the off-chain asset to which it is linked. So I don't think it's clear to us at the moment that a distinction needs to be made between those two different types of assets. I think I'm probably going to stop there. I'm conscious that I've talked for quite a long time. I am, of course, happy to answer any questions on any of that. Really just to say that the issues that at the moment we are considering that we will need to spend a lot of time thinking about are no different, unsurprisingly, to those that you've heard about already on this panel. So it's probably not a good use of my time to reiterate those, other than to say that, of course, it is very much on our radar that those are the things that to which we need to pay attention, and to which over the next year to year and a half we certainly will be paying attention, both in terms of our sort of in-house research and in terms of listening to suggested solutions or information or experience from elsewhere. So yes, I think I'll wrap it up there.
Right, I think I'm last. I will keep my contribution short for a number of reasons. I think we would like to leave some time for discussion and perhaps some questions. And also because I think all the prior panelists who went before me have been quite comprehensive in terms of their coverage. So I'm Kelvin now. I am at the National University of Singapore. I have been looking at the digital assets, cryptocurrency space for a number of years now. I am what is commonly regarded as a crypto skeptic. I haven't really focused on the conflict of laws problems in particular. I was supposed to join this panel together with a colleague at the same time, but my colleague can't make it at the end, which is one of the reasons why I've asked to go last. I suppose I will work sort of backwards in some ways. So one of the problems I think both Kirsten and Matthias have identified is the problem of identifying where the lex site is for crypto assets or digital assets. And this is, of course, a huge problem because the ledger is decentralized, the nodes are all over the world, so there is no citus, and it's not a tangible object either. The common law has actually a solution. It may not be a logically satisfactory solution, but I think it is a practically workable one. And this is a proposal from Professor Andrew Dickinson in the University of Oxford. He contributed a chapter to a book edited by David Fox and Sarah. And his position is that, well, we could take the view that the citus of the crypto asset is the place of habitual residence of whoever the owner is. And this position has been adopted by the English High Court in at least 2 cases that I know of. Ion Signs and Persons Unknown, and Fetch AI and Persons Unknown. Now, so I think this is a practically workable solution in the absence of any choice. And this may be something worth studying by other legal systems. One of the big difficulties in this area, of course, is the civilian common law divide, and I would say actually the Germanic civilian common law divide as to whether crypto is or digital assets are property. Germanic civil law systems have tremendous difficulty fitting digital assets into their law of property because you have a very strict view of what things are, and only tangible things count. We see that here in Asia, in Japan, certainly, where in the famous Mt. Gox case, Bitcoin was held not to be property. But there's also a slightly different sense of the word property, where it's actually closer to what Matthias used, assets. So assets is a slightly broader use of the vocabulary. The common law is famously fluid. We mix up the 2 terms. Property versus assets, which is why we have no problems fitting it within our law of property. Now, I think from a conflicts of laws perspective, what we call property in terms of determining who has the best rights to a particular asset, we must be looking at the assets, the wider terminology. Now, there is a possible solution, and I think that it deals with the so-called quote-unquote property law problems. But coming back to the contract choice of law problem. So I think both Matthias and Kirsten has mentioned, we can just simply apply standard choice of law for contract. But one question I actually do have for the other panelists really is, what is the law of characteristic performance, right? So in a normal contract, so where I pay money for goods, we have no problem figuring out what the characteristic performance is. It's delivery, right? So what if I pay money for Bitcoin? So which is the characteristic performance? Is it the payment of fiat or is it the delivery of Bitcoin? And if it's the delivery of Bitcoin, where does delivery happen, right? Because again, this happens all over the world, supposedly simultaneously. And it gets even more complicated where you have an exchange of 2 crypto assets, 2 digital assets, right? So if I exchange Ethereum for Bitcoin, what is the characteristic performance? So I think that there are still problems, even for the transactional side of digital assets choice of law, that might be worth thinking about. So what is the place of characteristic performance? Now I'm going to then come to something that Sarah talked about. Sarah, in the Law Commission, in the consultation paper on digital assets, has proposed that digital assets need to be accommodated under a third category, a tertium quid. I disagree, but I think that this agreement at the domestic law stage may not be terribly important for a private international law perspective, because at private international law, the characterization of an issue is usually divorced from the narrow domestic characterization. So something that English law would not regard as a contract can nevertheless be characterized as a contract for private international law purposes. So I'm not sure that the tertium quid or not tertium quid debate at the domestic English law level will have very much bearing on the choice of law problems that we are faced for private international law. So I think regardless of whether you take the view that it is a tertium quid or is not a tertium quid and we can regard it as a thing in action, will not, I think, help us at the private international law choice of law stage. Now, the remaining thing I want to really address is this. I'm actually wondering, whether, and these are all very interesting questions and they're all very problematic issues, but I think that one of the bigger problems with the digital assets space is actually not legal, right? The law will work out these solutions, and we may disagree on what the perfect solution is, but when faced with a problem, the courts will come up with a proper choice of law rule. The problem really is technical, right? I believe Kirsten mentioned that most of the transactions are pseudonymous, right? They are immutable. Now, if you look at the disputes that we have seen, certainly on the common law side, most of the cases are still interlocutory stage. Most of the defendants are persons unknown. There are a lot of instances where people just have no recourse, because first you have to trace the assets, right? Now it can be done because the blockchain will leave a transaction trail. Even if you run it through tumblers and whatnot, there will be a trail. You can follow it, but it is costly, right? You are going to have to hire, a digital forensics expert like Chainalysis or one of Chainalysis' competitors. Then after you identify, you find that your 3 Bitcoin is now in public wallet, which ends in 678, for example. Then you've got to go through the trouble of trying to find out who this person is. Now you can sue persons unknown, but you can't get effective orders against persons unknown, right? So most of the claims have been where you can trace the Bitcoin or the digital assets to an exchange. Now that's not going to be all. So recovery is usually a small percentage of whatever is stolen. And trying to identify who these people are is even more expensive than that. So most of the efforts we have seen in terms of trying to identify these pseudonymous account holders have been restricted to essentially terrorists or child pornographers. So the technical obstacles, I think, are going to be far more significant than the legal obstacles. We will solve these choice of law problems, but the technical obstacles are quite difficult to get around. So I wonder whether, and this is something, I recently presented a paper on whether we should recognize property in crypto assets. I take the view that we should, even though I am a crypto skeptic, but one of my co-panelists took the view that no, we just shouldn't, right? So this is also something that I think we need to think about. Should we be investing this time and energy to providing a choice of law solution when the technical problems are actually far more insurmountable than the legal ones, right? I think I will end here so that we have some time for discussion.
Thank you, panelists. At this time, you may respond to points that you've raised. Respond to each other's points. I will also explain the Q&A system. If you are using the Teams desktop app, you have access to a Q&A function at the top of the screen. If you ask your question there, the panelists and the moderators of the HCCH can see them and choose questions to respond to.
May I take the floor and directly respond to Kelvin, who asked some interesting questions about the transactions law in the civil law systems. Thanks for clarifying many aspects of the common law to Sarah and you. As for the Rome I regulation, let's not forget it also applies in the UK still, because it has been transposed into domestic law. It is true that it uses the characteristic performance. Now, in the case, Kelvin, that you mentioned, where somebody buys Bitcoin with fiat money, let's say with US dollars, I think it is clear, I would say, that the characteristic performance is not the fiat money, because it never is, but is the object that is bought. And in this case, it's Bitcoin. Okay, that you call Bitcoin a cryptocurrency doesn't change the fact that you can buy it, right? As you said yourself, you're buying Bitcoin with fiat. It also already implies that the object is Bitcoin. Now, much more difficult, I agree, is the question when you exchange, for instance, two cryptocurrencies, a Bitcoin versus Ether or Ripple or what have you. In that case, the Rome I regulation provides a subsidiary rule in Article 4, paragraph 4, saying when we have like barter transactions where we can determine what is the characteristic performance, then we have to look at all the circumstances of the case and all the other things that might play a role. And that could be, for instance, the question where the contract was concluded, or whether there is any other point in the transaction that points to a particular legal system. Now, then you ask the also very tricky question, where is the delivery of the characteristic performance if Bitcoin is the characteristic performance? Now, the beauty of the Rome I regulation is that we don't have to determine that, because the place of delivery plays only a very, very minor role in the determination of the applicable law, only for minor aspects such as the taking into consideration of the rules at the place of performance. But the main rule is we take the habitual residence of the person that provides the characteristic performance. So when the seller resides in Singapore, we'll take Singapore law, no matter where the goods are to be delivered. And that spares us from this very difficult question where the delivery takes place. As for, if I may say, Andrew Dickinson is a good friend of mine, and I have much esteem for him. And I have some sympathy for his idea of taking the law of the owner of the cryptocurrency. However, that begs a little bit the question, how do we determine who is the owner? The owner doesn't live in the abstract. The owner is the owner because of a particular legal system. And our question was to identify this law that tells us who is the owner. So to determine the law governing proprietary aspects by referring to the law of the owner somehow is very circular. And that's why I think it's better to refer to the place of the person, of the habitual residence of the person that is currently in control, because control is neutral, it is factual, it's not determined by a legal system, it's technologically determined, and that's a short criterion. And as for the technological problems of finding these persons, I think Of course, everything you said is perfectly right. So there are huge technological problems, but we are not computer engineers, unfortunately. We are here to do law, and that's what we are doing.
Yeah, I think on the just that final point, Matthias, I agree entirely with your second point, which Andrew knows. I've also said to him. On the final point, I think you used the word, Kelvin, when you talked about the problems, the technological problems, as insurmountable. They're very difficult, I'll concede. I'm not sure that they're insurmountable. I'm sure ultimately it will be worked out. But I think, you know, similarly to what Matthias was saying, when we've been doing our work previously on how to characterize digitized assets, which obviously you need to do to answer some of these questions. So what is happening when you transfer a digitized asset? Where does that transfer occur? Because what actually amounts to the transfer of that thing? So I also agree that sticking to factual issues or factual concepts, I should say, like control, allows you, I think, to identify the essential characteristics of that thing. But another thing is quite a few of the people we have spoken to at the Law Commission as we've dealt with legal issues in general is, I mean, I know, Kelvin, you described yourself as a crypto skeptic, but we have encountered people who are a lot more crypto skeptic than you are and seem to take the view that all of crypto is a Ponzi scheme, and that therefore we shouldn't waste our time trying to think of legal ways to deal with it. And I'm not suggesting that's your position. I know it isn't, but I think it's very important to proceed as if there is a sort of a normative neutrality to these things. And we have to proceed as if I think these technological issues can be overcome, because in doing this work, we're in no way saying, oh, you know, all crypto is a good thing and everybody should invest in crypto and they're always going to be positively valuable assets. Of course, that's not the case. But even when they're not, you know, it's a bit like guns, I suppose. You know, we still need to have legal recognition of these things and to know how to deal with them. So I think sticking to the factual and not getting on this level, and for these sorts of questions, not getting bogged down with the normative is really quite important.
So if I can sort of respond to Matthias and Sarah's point, responding to Andrew's solution. One of the big difficulties because of the pseudonymous system, which your solution will necessarily entail, is the person who is in factual control may not be a party to the dispute. And if so, the court really has no means of determining where this person is habitually resident, right? Whereas the advantage, I guess, of Andrew's solution really is that usually it is the owner, or once upon a time owner, whose digital assets have been quote unquote stolen from him or her, and he or she is bringing suit, and he or she says, you know, I'm habitually resident in, let's say, England or Singapore, as the case may be, and you know, that transfer away from me was ineffective, and then you can use English law or Singapore law to determine that. And then because that initial transfer was ineffective, then all subsequent transfers are also ineffective, right? Whereas on your solution, this factual solution, you will have this problem of how do you determine if there are several layers of intervening transfers, what law governs how each transfer is validated or not, right? And maybe I should clarify, Sarah, I am actually very, very close to the view that almost all of it is a Ponzi, in the sense that, okay, I need to clarify. So I don't think that everyone in the crypto space is intending to create a Ponzi scheme. And this, if you haven't come across this op-ed by Matt Levine on Bloomberg, I think it was 2 days ago, you should try and go and search for it. The way the crypto ecosystem is designed is in such a way as to incentivize early adopters to come in with a view that their early investment will, rise in value, and they can sell it on to the next person, or what Warren Buffett says. You're not creating value. The only value you're creating is that there's a sucker down the road that will buy it from you. Now, many of the people in this space will be, they're not intending to do that, right? They're not trying to create a Ponzi scheme, but structurally, the incentives are such that it has Ponzi characteristics. So the best description I've come across really is Nicholas Weaver from Berkeley has described it as a self-assembled Ponzi scheme, because the incentive structure is such that most of the people are going in because they're hoping to sell it to someone else. And the actual use case has been a huge problem.
Would you agree, though, that doesn't mean that? I mean, to my mind, I mean, I don't take that view, as you know, but if that were my view, I mean, I acknowledge that is certainly large parts of crypto at the moment, but that's sort of an a fortiori reason for developing coherent legal rules, isn't it, rather than a reason for not doing so?
Oh, absolutely agree, Sarah. So I'm not saying stop looking at this. So I don't subscribe to it. I was just putting it out there as a possibility since no one else has. So this is a view I think Julius Grower in Cambridge mentioned in terms of we shouldn't recognize this as property, right? Because this is mostly a Ponzi scheme. It's environmentally harmful, and I think this is a legitimate view. I don't agree with it, but I think this is something that needs to be taken into account.
Yeah, I mean, I suppose on the pure environmental points, I'm sure he's aware of the merge, which I think is happening today, isn't it? Or what day are we? Thursday, which should make a huge difference, at least as far as he's concerned, in terms of environmental concerns. But I think, I mean, I'm just, as you know, Kelvin, very optimistic in this space, and I think that it, particularly in terms of environmental impacts, I think that those problems will work themselves out very soon, and that there will be more non-nefarious use cases, I think, for crypto. But anyway, I realise I'm going off on a tangent, so I'll stop on that particular point there.
Dear panelists, if I may, thank you very much for this discussion. I'm sorry to have to cut this off right when it's getting to I think some points that are very present in the minds of the general public as to the aspects of crypto and whether or not they provide the public use that in the end. So now I will remind everyone that the live sessions, the broadcast of the live session will be posted to our YouTube channel after the conference. And we will transition now to the next session. We'll take a few minutes to get the next speakers online. And again, thank you very much to this panel for your contributions to CODIFI.
Thank you.
Thank you.
Thanks.